This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
We are now going to be doing our question and answer period with the questions that have come in today. So it looks like right now we have about 36 questions. The first question is there a way that the association can prevent a lease between an owner and a tenant from being extended if the property sells before the current lease has expired? Great question. So I think you want to look at the Landlord-Tenant Act because typically if there is a lease in place at the time of the sale, unless it's going to be in the lease agreement, probably there's going to be what the outcome is on that, right? So the private lease agreement between the owner and the tenant is probably going to address how that will be handled. So it's unusual that the association would have any say in that. So I don't think that we could prevent it. It's possible, although I've never seen it, that you might want to consider doing a CC&R amendment of that type. But that would be really unusual. I think basically that's going to be a landlord-tenant relationship issue that's going to be outlined in their lease. Next question. Per our bylaws, we were to have a meeting of the board of directors 10 days after our annual meeting, which happened in May, where our board was elected. 2 of the 3 directors refused to still elect officers, and most recently postponed the 7/21 meeting where they stated that officers would be elected. What do we do now? How can we conduct business if 2 of the 3 officers refuse to follow the bylaws? Is the election still valid? Okay, so you have a question of, you've got a valid board. You have valid directors at large right on your board. But right now, you're having trouble getting officers elected. And there's been kind of a long period of time between May and July now where you still don't have your officer slate in order. And, why is that important? It's because the officers have certain responsibilities. Like the president is the point guard for your community and is really kind of managing the direction of your community. The treasurer is overseeing the finances, the secretary is overseeing, the paperwork and minutes of your association. So this really needs to be done. So first question would be, is the election still valid? Yes. You have directors at large. My recommendation is that you get this meeting scheduled right away. And I don't understand why 2 of the 3 directors are refusing to do this, but they are breaching their fiduciary duties, in my opinion, not acting in the best interest of the association by refusing to appoint officers. And they really need to step up and get that taken care of, and just have it at an open board meeting. All you need is the 48 hours notice. And I would strongly recommend that you get this done in July. Next question. A committee has been meeting in an open Zoom meeting discussing a $240,000 landscape contract. A motion was made, seconded, voted on, and passed. After the meeting was adjourned and the Zoom feed was cut to the homeowner participation, the committee made a second motion regarding the same issue and passed that new motion. And that one was their committee report to the board. Was the second motion after the meeting was adjourned and closed valid? So I have to look at the minutes on this to see specifically what happened, but so it looks like it's just like a formality. It looks like probably what happened here is that during the board meeting, the board voted to do something. And then you're saying that the meeting was adjourned and the Zoom feed was cut to homeowner participation. I don't know if the meeting was actually adjourned or if you just started having the homeowners make comments. So it's really kind of a tough call for me on this. But if the meeting ended, the second motion, they should just reaffirm it at a future board meeting just to be safe. But if the meeting really didn't end, which kind of feels like what happened here, because the homeowners started participating and then there was a second recommendation and the board apparently passed the second recommendation, it's possible that that could be valid, but just to be safe, I'd probably just at the next board meeting revisit the issue and reaffirm the decision, especially since we've got $240K involved here, a lot of money. Okay, are there any remaining requirements for posting COVID-related notices at HOA outdoor community pools? No, there are not. Now some associations are, just making up their own things for safety reasons, but there are no state mandated requirements anymore. Next question, which is number 5. Can you address dealing with QAnon affiliated people who are homeowners? Also address if a Black Lives Matter flag or sign is protected. Okay, so 2 political hot buttons, right at the top of my questions. Okay, so I'm not exactly sure what you mean by dealing with QAnon affiliated people who are homeowners. Without more facts, it's hard for me to talk about that. Maybe I can guess that they might be, displaying like flags that are aligned with a certain former president. I think we got to look at what they're doing, and is it a violation of your documents or state law? And if it is, then take the appropriate enforcement, measures. Along that same line, having like the Black Lives Matter flag, or really we're seeing all kinds of different flags now on different political issues, whether it's I support the police or I defund the police, or, this is a weird time in our country, let's face it. And so here's kind of my golden rule right now. And I'm going to be honest with you, before the pandemic, this was not my golden rule. We were what I would call, strict constructionists in terms of how associations should be run, meaning that look at the state law, look at the documents for each association and follow state law and follow the documents. However, over the past 15 months, we've had a lot of unique things happen in our country. And, a Black Lives Matter flag or a political party flag, that's not something that we really envisioned was going to become such a hot topic in Arizona in 2020 and 2021. And so what we've been telling clients right now is as long as the flag or the sign doesn't offend anybody, that you should just let it be. I had one association in Arizona where they didn't like that somebody they had a flag hanging from their garage area outside the garage door. So it was up all the time. And it wasn't anything offensive. I think it was, something along the lines of Black Lives Matter. And, I said to the board, I don't think I would enforce that, even though it's not covered under the state statute as being a flag or sign that they're allowed to fly. And it's not covered under your association as a flag or a sign that they're allowed to, have on the property. We're in a time in our country where this is an issue that is an important public issue. And if you, take it down or you send them a letter or you fine them, this is going to become a much larger issue on a state or federal level. And I recommend that you just let it be. I think we let these things like this be for the rest of 2021, as long as the sign isn't offensive. So if it has, like a swear word on it, or it's, something that would be associated with the KKK, those obviously are not going to be something that would be allowed. But some of these other things, it's a sign of our times. And I think associations need to pivot and not be such strict constructionists at this time. Okay, next question. Our HOA board has asked to meet with a small group of residents to have them talk about their concerns with the board. The board is having their HOA attorney present to lead the meeting. Why would the attorney be required to attend, and should the residents be concerned by this? So I would say no, I wouldn't be concerned. I mean, I think the board, I go to a lot of meetings, with the board and with residents, and I think probably the board feels more comfortable having their attorney present if you're raising a bunch of legal issues, so that the attorney can be the person to respond on the legal issues. That would be my feedback. Should you be concerned by this? No. Because remember, the attorney is the attorney for the corporation. It's not for the individual board members. So I wouldn't be concerned about it. If your group has an attorney, you could consider bringing your own attorney if you want to, but it's not necessary. Next question, how can homeowners vote to remove the current management company? So the vendors of the association are selected and deselected by the board. And so if the homeowners are unhappy with a vendor for the association, such as the management company, get elected to the board. So you're the decision maker, petition the board, tell them that you're not happy with this particular vendor. Those are the routes that you can take to get the outcome that you want. Next question. A few weeks ago, during a First Friday Q&A session, I believe you mentioned a situation where homeowners would have to vote to approve money being used from an HOA's reserve fund. Would you outline situations where homeowners and not the HOA board alone would need to authorize the use of some of the existing HOA reserve funds? One of our current board members is also a member of an HOA on the East Coast, and he is unaware of any time that homeowners had to vote to authorize use of reserve funds. So great question. So sometimes your documents will require a homeowner vote. So some antiquated old documents will say something along the lines of, anytime the board has a capital expense that's over $10,000, that they have to get a vote of the membership to spend over $10,000. Again, it's the older associations that may have those type of provisions in their documents, but that's a good example. Next question, do rental restrictions have to be in the CC&Rs or can they imposed in a rules and regulations document? They have to be in the CC&Rs. So you might want to look at our cheat sheet on implementing rental restrictions on our website at mulcahylawfirm.com to give you more information. Next question, if an HOA is going to amend the CC&Rs to ban short-term rentals, is there a need or is it a good practice to allow existing owners the right to keep their short-term rentals? So great question. So it's a strategy, of course. Anytime you're doing an amendment to your CC&Rs, there's some strategy in terms of what you're going to have the residents vote on. Is there going to be grandfathering language? And is it a good idea? It could be, because you want to get a yes vote, for the amendment. And maybe the only way you get a yes vote is to grandfather the existing owners that are, that may want to have a short-term rental in the future. Or maybe you grandfather only the owners that are doing rentals right now. So talk with your attorney about it. It's a strategy for sure to get more votes. Next question. We have an owner who has decided that she is in control of the gate next to her unit that provides access to the common areas. She wants to unlock it when she needs to leave it unlocked until she decides, and doesn't want the association vendors like landscapers or pool people to use that gate. If another resident sees it unlocked and locks it, which is pretty common here as a safety measure, she will call the police and sue the board. There are other access points, but it seems like she is taking control of an association and community asset. Any thoughts? Well, yes, I think that concerns me, because this gate appears to be a gate that's not on her property. It's a common area property. And she's trying to become the sole determinator of whether or not this gate should be left open, locked, unlocked. And that's just not appropriate. So, I cannot imagine why she thinks she has the right to call the police on this or to sue the association. And so what I would recommend is that you have your attorney write this homeowner letter explaining all of this to her, and letting her know that this is not appropriate behavior and she needs to cease and desist from doing this. Let's see. The next question is, if at a meeting, a member engages in disruptive, abusive, or other very inappropriate behavior, and even when asked by the president or manager to stop, continues such behavior at that meeting, can that member be banned from meetings for a certain period of time, say a year? Our board would like to add this policy or something like it to our bylaws under revision. We understand that enforcing this will be a challenge, but we do want a policy to deter bad behavior. Okay, so you've got a bad behavior owner who's coming to the meeting wreaking havoc. So I suppose you could do an amendment to your documents to include that in there. However, I think it would conflict with state law, which gives all owners the right to attend, listen, and participate at board meetings. Maybe if you gave that person an alternate way to participate, like a Zoom dial-in or something like that, where they would still be able to be there, but they wouldn't be there physically, that might be possibly one solution. But, what's nagging on me here is the open meeting law, and I would really advise against doing that at this point with this owner. I think some things that you might want to do is write the owner a letter regarding the behavior, say it will not be tolerated, that they'll be asked to leave if they engage in this type of behavior. You may need to bring in a security guard to help you manage the meeting better. But banning the owner from the meeting, I worry that they could sue you for an open meeting violation, and they probably would win. Regardless, document all the bad behavior in the file so that this does go to some sort of litigation. You have proof as to what exactly this owner was doing that's a problem. Okay, let's see. Next question. Sorry, I lost my place here, so I'm going to go back up. Okay, next question is, if parents own the property and a daughter and family live there and think they are the rightful owner, due to POA, power of attorney, does the daughter need to be on the deed? So just because somebody is the power of attorney doesn't mean that they have rights within the association. So the weird thing about a power of attorney is, in this case, it looks like the parents let the daughter and her family live there. They gave her the power of attorney, the POA, and she thinks that that gives her rights in the association. Well, the reality is that she's not the record owner. Her parents are. So she does not have the right to vote. She does not have the right to serve on the board. She does have a right if her parents designate her in writing as their designated agent to attend and speak at regular board meetings and at the annual meeting, just like any other owner would, but there'd have to be a designated agent form in writing for that purpose. So bottom line is that even though she may have a power of attorney, it doesn't really give her any rights at the association. Next question. Are there any cheat sheets or videos on taking minutes at HOA board meetings? Is it prudent to audio tape meetings? And if so, how long are minutes retained? Okay, so we have some great cheat sheets that I would like to share with you. Both of them are from our website. One is on the open meeting law and rules for recording association meetings. The second one is on community association board meetings. Both of those will be very helpful resources to you. The community association board meetings, on the flip side, has a section that talks specifically about how to take perfectly proper legal meeting minutes that you should take a look at. Is it prudent to audio tape meetings? I mean, you have the right to do that if you want to. So if you are going to do that, make sure that you check out the cheat sheet. You should notify the board that you plan to do it at a meeting. And, that's something you have a right to do. Is it something you should do? I really don't think it's necessary. The meeting minutes are the official record of the association. The association should be keeping the meeting minutes indefinitely, forever. Those meeting minutes should never be destroyed. Next question. How does a homeowner address an issue with discrepancy in vote count recorded by members and appointment of new board member due to resignation when they stated to members they were appointing the next highest vote getter? Okay, this is a really common problem that happens. So you have an annual meeting, let's say, right? And there's 4 people running for 3 spots. So 3 people get elected, and then there's this leftover person, right? And so then something happens where, that person, somebody gets off the board, then somebody quits, somebody moves, whatever. And the question is, do we have to appoint the person that just ran at the annual meeting and did not get elected, or can we appoint somebody else? And unless your bylaws give direction on this, which honestly most don't, the board really makes a call on that. So if the board doesn't, they don't have to appoint the person that was the next highest vote getter. They don't have to. The other part of this question was they can appoint who they want to, is the bottom line. The other part of this question is, how does homeowner address an issue with discrepancy in vote count at the annual meeting? Request the ballots and recount them and see if there is a discrepancy. If there is, bring it to the attention of the board, ask them to refer it to their legal counsel to talk about it. Next question. We have limited access to the office to board members. Recently, we have hired a bookkeeper who is a community resident. Is it appropriate to allow to the office allow access to the office by the bookkeeper without a board member present? Our board is not in complete agreement. As a broad question, can we vote on this? Okay, so a couple weird things on this. So why do the board members have limited access to the office of the association? I mean, they're running it. They should have access to it, would be my feeling. I also feel that the bookkeeper, if the person is even if they're a resident, they're the bookkeeper at the association, they should be allowed access to the office. I can't imagine why there would have to be a board member present. There's like a lot of fishy stuff on this one. I'm not liking that. Can we vote on this? I suppose you can. I mean, it's policy, but I don't understand why everybody wouldn't have access to the office. If you're worried about the bookkeeper spilling the beans on confidential information that they might come across, you should have that person sign a confidentiality agreement, and ditto for the board if you're worried about that too. Okay, let's see. What about managers that disregard the board members and do what they want instead of board voting? Well, yes, what about them? Time to get a new manager would be what I would say. The manager acts at the direction of the board. Your law firm acts at the direction of the board. Now, obviously, if I disagree with the direction that the board's taking, I'll let you know, in writing, but I act at the direction of the board. I don't go off and do things without getting the board's buy-in and approval, and neither should the manager. So maybe it's time for a manager change. Maybe it's time for a management company change. Maybe you just need to have an informal discussion with the manager to remind the manager of what I just said, that they act at the direction of the board. We have an owner who files lawsuits against the HOA continually. Can the owner be responsible for the HOA legal fees? It really depends on what the lawsuit's about. So if it's a breach of contract, meaning like the CC&Rs or bylaws or rules of the association have been breached, under state law, the prevailing party is entitled to their attorney's fees. I'd have to look at what your documents say about, is the owner or the association entitled to attorney's fees on the type of case that the owner is filing against the association. It just really depends. But 9 times out of 10, if an owner is filing a lot of lawsuits against the association, it's for breach of contract of the documents. So you should be entitled to get your attorney's fees, but you have to be the prevailing party. In most circumstances, you have to be the prevailing party, and you want to look carefully at state law on that and also at your documents. Okay, next question. With recent news about assault and murder in group homes, is there a way to identify a buyer and prevent the sale of a property in an HOA for this purpose? What can be done if such group home is already present? Okay, so I'm not aware of assaults and murders in group homes. I must be under a rock, although I have to say I don't watch that much news anymore. Under the Fair Housing Act, there is an exception for group homes. Associations cannot prohibit group homes that are acceptable under the law. So I would suggest that you look at our federal laws cheat sheet on our website. And it's at mulcahylawfirm.com. And we'll give you a list of the type of group homes that are allowable in an association and that we cannot in any way prohibit. If you think there's something going on in the group home that's already present, you're welcome to contact the state agency that regulates group homes or the police and have them look into it. But generally speaking, you're not going to be able to prohibit future group homes or the current group home that you have in your association, as long as it's the type of group home that's allowable under Arizona and federal laws. Next question, do letters being sent to homeowners from the HOA lawyer need to be sent certified? No, they don't, not unless the documents require that. What is the best way to deal with a sociopath who is an incessant complainer, constantly threatens frivolous lawsuits, never has the facts on her side, has sued the HOA in the past, never has proven her case? She doesn't seem to care that she's losing money in attorney's fees and assessments, continues to manufacture new grievances. Okay, that is a very common problem that you're talking about here. I think when you have somebody who's really difficult like this person, and it does sound like this person is a sociopath, I think you have to come up with a specific strategy for handling that person. And it may be that all communication between her and the association goes through the association's attorney. And, it has to be in writing. She can't send emails. But whatever you're doing in the past isn't working. So you need to reset, maybe have it all communications between the attorney. When I have a situation like that, I'm very firm with the sociopaths, let's say, and I say 1 communication a week to me, just put it all in one letter, send it to me US mail, and we'll respond back to you within 10 business days. And that's how we do business with it. If she raises anything that's a problem, we get it fixed. Sometimes associations make mistakes. That's how things roll, right? If it's not a problem, I respond back and say, you are incorrect. And I don't spend a lot of time on it. I just say, you're incorrect. And if she continues to sue you, yes, it's a problem because your insurance is probably going to go up if you're making an insurance claim on each one of these. Next question. We have an ex-board member who has distributed some confidential information to owners. We're not sure how she has gotten it. She also is currently doing several violations of the rules and regulations. How can this be dealt with? Well, I probably would communicate with the ex-board member and say, we became aware that this is happening, that confidential information is being distributed. We just want to remind you that this is not acceptable. You'd have to have actual proof that she's doing it to send a letter like that. Remind her that her responsibility when she served on the board was to keep information confidential that extends past the time that she's on the board, in my opinion. So she shouldn't be doing that. If has several violations on her property, treat her just like any other owner. Okay, next question. It is not clear by the wording in the CC&Rs that there is a requirement of homeowners to maintain landscaping between the common wall and the sidewalk. The CC&Rs only state the area between the sidewalk and street, which is just an expansion joint in our community. The CC&Rs do state that the HOA is responsible to maintain the exterior of said common walls. Do we need to amend our CC&Rs to change the wording between common walls and the sidewalk? Yes, you do. You may want to have a lawyer look at it before you go to the expense of that, because if it's on common areas, the association may have to maintain it already. But my initial thought is, based upon what you've told me, you may have to do that. You may have to amend the documents. Next question. What about a homeowner that harasses and bullies a board member? What I would say is go back and look at the cheat sheet that I mentioned in the presentation that I gave today. It's called Dealing with a Difficult Person or Dealing with Difficult Owners. We have a section in there on harassment. We give the different legal options, including getting an injunction prohibiting harassment. I would encourage your board member to look at that, see if it qualifies for making threats against the board member or actual physical harm against the board member, and consider getting a injunction prohibiting harassment. Another option would be to have the association's attorney send a letter to the harasser, bullier, telling them to cease and desist harassing board members. We've done that before. Regarding tenants, can an HOA require homeowners to include a condition in their lease that says the tenant will comply with the governing documents? The only way you could require it would be as if it was in the CC&Rs. And I have seen some associations that do that, but not that many, like less than 5. Disregard of the owners. When owners challenge a board's ruling, which is factual, not to be in compliance with the CC&Rs or guidelines, and the owner is dismissed as being a difficult sociopath problem, which management can then take license to control by dismissive silence. Where is the defining line between legitimate anger in principle and unsubstantiated griefs for demonstration only? So here's what I would go back to. Business-like behavior. In a business, people can agree to disagree and move on. Hearing the words like anger, griefs, I think it sounds like this is turned into, an unprofessional situation. So what I would encourage both sides to do is get back to the basics. Be professional in your dealings with each other. No name calling. You should be calling someone a sociopath. If you have issues with how the association is handling something, be, professional in how you express it and factual. And don't show anger and raise your voice. Just, this is a business. It's a business matter. I'm asking why this is being handled in this way, or whatever your question is, and then wait for the business-like response. You shouldn't be disregarded, though, or you shouldn't be called names. That's not appropriate. The board needs to act in a business-like manner too, and treat you professionally, because ultimately they answer to you. They answer to all the homeowners. So, even though we're unpaid, our job is to do a good job, running the association. And sometimes part of doing a good job running the association is taking a little grief from owners who are unhappy about things. That's what you signed up for. And you have to have a little bit of thick skin. Okay, next question. Is it being stated that the board would talk to the owner? Would this be true when you have a full-time manager? It seems that this could lead the board members to do the job of a full-time manager. So it really just depends. If you want the manager to have communications with the owner or with the attorney, you just tell the manager that's your role. Sometimes in a self-managed association, there's only the board that can have those communications. So it really just depends. You're in the driver's seat. You decide how things are handled in your association. Next question. We have a scenario of passing by someone's open garage. Community member notices that the garage is stuffed to the gills. Is it within the board's purview to request or demand an inspection? I think it is. I'd look at what your documents say, but I think I would, assuming that your documents have inspection rights, I wouldn't shy away from asking for more information. It might prompt the owner to clean up a little bit. So I'm not opposed to that at all. Sending a letter saying a neighbor, noticed this and we're looking into it on behalf of that. Next question. Owner sits on his balcony and smokes all day long. He has a court order to not allow smoke to infiltrate the halls and other condos. When he stands up, pants only to knees. Yikes. Not just occasionally, but all the time, every day, all day long. When he stands up and it's exposed, wow, this is getting crazy. Bends over to flick his ashes in the ashtray, definitely has mental health issues. I called social services and left a message, but have not heard back from them. Suggestions. Well, you may want to involve the association or whatever city you're in, the police. If he's exposing himself, you should be contacting the police, of course. I hate to say take pictures, but you may need to take pictures so you can prove that he is in fact doing this. The smoking on the balcony, we have to just look at and see if that's allowed under your documents or not, and if it's creating a nuisance or not. So there potentially could be an issue there that the association gets involved in. What if the difficult person is the HOA president? Oh my gosh, I've seen that before. That makes things really hard. I think the president can be removed by a majority of the board from his title, right? He can have his title taken away from him. If the person becomes that difficult, that is the remedy that you have. Either remove the board votes to remove the officer title, strip him of the president title or her of the president title. Try to talk with them first and explain, hey, we find your behavior problematic, difficult, makes it difficult for us to work together as a team. If they don't clean up their act, then the pivot would be to remove them of their officer title. Now, if you want to get this person totally off the board, you're going to have to follow the petition procedure for removal of a board member, which is more complicated and requires a member vote. And that's, in more detail on our top 10 legal things you need to know about associations, which is on our webpage, mulcahylawfirm.com, under our cheat sheets tab. Okay, clarification is needed. Open versus closed meetings. In order to chat about the need to meet, is the board not allowed to communicate without publicizing a meeting? The board just needs to spitball so we don't sound disorganized or uninformed during actual meetings, so we can be on the same page about why we need to meet. Further, are specific resident behavior fees, violations, and discussions under executive or open? Okay, so the first thing is anytime a quorum of the board is meeting to discuss association business, it needs to be an open board meeting. So doesn't matter if you're spitballing around, trying to get organized, getting informed, getting on the same page. It's an open meeting. It needs to be an open meeting if a majority of your board is meeting to discuss association business. So our specific residents' behavior, fees, violations under executive are open. So anytime we're discussing like enforcement actions against an owner, that's going to be in the executive session if the board chooses to put it in there. The residents' behavior, I don't know what exactly the behaviors. It might fall under the personal behavior of the resident. It could possibly fall under executive session. I'd have to know more to comment on that. Okay, next question. Difficult people. Resident moves in without a dog, sees someone else with a dog, a large trained service dog. But the association has a 20-pound pet weight limit per the CC&Rs. Person gets a large dog then has it listed as an emotional support animal. What can the HOA do, if anything? I mean, assuming that they set this up as a legitimate emotional support animal and that they have a doctor's note saying that this is an emotional support animal and they need the larger pet for that or whatever, there's nothing you can do about it under the Fair Housing Act. I'd suggest that you look at our cheat sheet called Federal Laws on our website at mulcahylawfirm.com, and we have a section that deals with emotional support pets. How can you get someone to take the personality test? You ask. It's voluntary, of course. But if you're familiar enough with the DISC profile, you don't even have to have them take the test. Read my cheat sheet and you'll see the traits right then and there. So best case scenario would be, of course, to take the personality test. If they refuse, then you might want to get up to speed on the cheat sheet that we have on our website on the DISC personality test and working effectively with others, and try to figure out what their personality type is, and then look at the different ways to handle the personality types. Next question. Presuming architectural requests are considered association records, they are. Should all correspondence related to a records request be provided without debate? Yes, it should be. Next question. What if a board member is harassing a homeowner? Well, the homeowner has the same rights to get an attorney, write a letter to the board member, to the board. The owner can get an injunction prohibiting harassment against the board member. It just flips the same way, because whoever's being harassed has the rights that are listed in our cheat sheet on dealing with difficult people. And the association has some liability in that situation, so they need to be careful. Okay, next question. Bending the rules. The CC&Rs for the mentally handicapped homeowner and becomes unfair to the rest of the community. How to best handle this? So, we have to make reasonable accommodations under the Fair Housing Act for anybody with a disability. And so if we have a mentally handicapped homeowner and we are required to bend the rules, I think we just notify the residents, under the Fair Housing Act, we're required to do that. It's the law. We can't violate it. So I think that's the best way to handle it. Just be upfront with the owners if anyone asks about it, and still enforce the rest of the documents against any owner that doesn't fall in that category. What information from a board meeting needs to be included in the board meeting minutes, such as issues brought up by homeowners and board responses, which board members voted yes or no on motions? Okay, so go back and look at our cheat sheet on board meetings. It's actually called Board Meetings. It's on our website, mulcahylawfirm.com. I'm all for shorter minutes. Really, minutes should be what was decided, not what was said. My feeling is that issues brought up by homeowners and the board's responses, it's not appropriate or proper to put those in there in the meeting minutes. Which board members voted yes or no, it just depends, whatever your board prefers on that. On controversial votes, you may want to say, let's do a roll call as to how everybody votes on it and then have the meeting minutes reflect it, but it's not necessary and most don't do that. Can't selective enforcement result in issues? Is it fair to other homeowners? How do you justify any enforcement during times when you do not enforce against certain things like Black Lives Matter or QAnon flags? Okay, so can selective enforcement of flags result in issues? It possibly it could, but it's unlikely. I think that there's rational justification based upon what's been going on in our country to temporarily not be as strict as we would normally be on these types of things. Does it invalidate your documents? No. Does it prohibit us from not enforcing other aspects of your documents going forward? No. Article in the Arizona Republic on July 11th. Could you elaborate on amendments must be reasonable? The HOA decided to implement a 14-year-old paint color, asking now to change the color, yet approved this color a year ago. Should these homes be grandfathered? Okay, so really great question. I did read that article, actually. Somebody sent that to me. It was talking about amendments to CC&Rs needing to be reasonable, and I would agree with that. So apparently you've got a paint issue at your association. A year ago, they told you to paint a color a certain way, and now they're saying we want a different color, you need to repaint. Well, I think we all can agree that paint is going to last more than a year. I would go back to your board and negotiate some sort of, agreement. I would think that they would be very understanding of that, and that they would give you a longer time to paint your house the new color. How long, it would just depend. It could be, paint usually lasts anywhere from 6 to 11 years, depending on, the prep time and other things. So I think you should get a more longer time period for that. How will what happened in Surfside, Florida affect homeowners associations, management companies, and board of directors going forward? That's a great question. I think we're going to have to wait and see. I think there's going to be more analysis of deferred maintenance, especially in condominiums, and how we should handle things that, need to be repaired in a more timely manner. I think there's going to be more inspections by engineering companies. I think I was just on a conference call recently with a group of lawyers from around the country talking about this same issue. We think insurance is going to be affected. We think, even hiring a qualified engineer is going to be, hard because they're going to be so in demand. What is that engineering's report going to, say? The engineering contract, are they going to say, I'm limiting all my liability, and are we just going to have to agree to it because that's what everybody's saying in their engineering, fee agreements? There's so many different issues that are pending out there. It hasn't been that much time that's elapsed since, the Surfside, Florida issue in Miami. So I think we have to wait and see. But I think the most immediate thing that's going to happen is there's going to be more investigation in terms of, is our building safe? What are the deferred maintenance things that we need to be handling? How can we fund all of these things that need to be fixed? Let's see. The Wi-Fi connection offered by the board failed at the last meeting. Reportedly, 3 of us on Zoom were disconnected. The board has not made any plans to fund or support attendance at meetings except in person. I cannot attend in person right now as I'm out of state attending to a medical matter. Is the board required to provide other owners a way to participate other than in person? They are not required, to give you, okay, so here's what I would say. The board, makes decisions about how the board is going to operate. So the board could allow the Zoom meeting. The board could allow board members and residents to attend via Zoom. They could allow board members and residents to attend via conference call. But really, the board is the one that's making the decision. Now, I agree with you. If you're out of state, it's so nice to be able to just dial into a Zoom meeting. I 100% agree with that. So I think my recommendation here is that your board be a little bit more fluid on this issue and allow people to attend by conference call or by Zoom or whatever. I think that's a reasonable request. So I would request that, and I think your board should grant it. Now, if they choose not to grant it, you don't have any legal remedies at this time to require them to do that. But I think the law is going to change. The pandemic, that will be a positive outcome of the pandemic. I think we're going to see changes on that going forward, where there are going to be requirements to allow those who can't attend in person to be able to attend meetings in some form. And that will be a direct result of the pandemic. Okay, so that's it. We got through 41 questions. Looks like we had over 150 people on the call today, which is just awesome. Thank you so much to the neighborhood services departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Surprise, Tempe, for your teamwork and partnership with our firm to provide this free education on HOAs and condos to your residents in your respective cities, and put together amazing virtual classes where we can still stay connected and potentially stay connected going forward too, as we start to plan our classes for the rest of 2021. Just so you know, we have a great slate of classes for August through December 31st. So make sure you're checking out our website at mulcahylawfirm.com. Our seminars has a special tab on the homepage, and I'll list all the seminars that we have coming up. And check out the classes that we have. I think we have 5 more classes through the rest of 2021. And we also have some live in-person classes for the second half of 2021. So if you want to get back in the classroom, make sure you think about attending one of our classes in person. But truly, a majority of the classes are going to be virtual for the rest of 2021 and possibly into 2022, because there's a demand for these classes. And we always have a ton of people showing up on our online platforms. So make sure that you're telling your cities, towns, and municipalities that this is convenient for you and that you're liking this type of education so that we can continue providing it to you. So thanks again for being here today. Take care, everybody.